Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast. I'm Jacob Stein, and we are going to spend the next 3 hours talking about asset protection planning. A fun way to kill 3 hours, I think. This is generally intended as a full-day seminar. So in the 3 hours that we have, we are going to cover pretty much all of the material that you see in the slides and in the outline that you got from NBI, but we will not be able to go into as much detail as in a full-day program, which means that there are certain areas that we will discuss briefly. We'll not go into a lot of detail. So if you guys have any questions about anything that I'm covering, if there are any issues that I did not address, or something you want me to get into a bit deeper, just email the question to NBI. I believe you have a way of doing that. They will tell me your question. I'll be happy to answer any question you have. Otherwise, just feel free to raise your hand, and we'll try to answer it that way. But emailing may be a little bit simpler. Okay, let's talk about asset protection planning. And the first question of the day, kind of the threshold question, is what is the goal of asset protection planning? What is it that we are trying to accomplish? The name asset protection planning seems to imply that the goal is simply to protect our assets, to make the assets unreachable by creditors. That is not really our goal. Asset protection planning is not about making assets unreachable by creditors. There are very few structures that we have where assets can be made unreachable, meaning 100% protected. There are a couple of structures like that. We will discuss them later on in this presentation. But for the most part, it is impossible to protect assets 100%. So what is our objective? I'll give you a recent client case as an illustration. I represented the client about a year ago. The client is a doctor. He practices in Orange County, and the client sits on the board of a nonprofit. There are 5 directors on the board of this nonprofit. All of them are doctors. This client comes to me one day and goes, "Jacob, we just got a lawsuit filed against the nonprofit. We were interviewing someone for an executive position with the nonprofit. We interviewed a bunch of people, and we ended up hiring someone we thought was highly qualified. Well, one of the people that we interviewed but did not hire filed a racial discrimination lawsuit against the nonprofit and against each of the directors of the nonprofit, joint and several liability." And this doctor says to me that he does not believe that this lawsuit has any merit. He thinks that it's a frivolous lawsuit. So he's not really concerned about this lawsuit in particular, but he says, listen, I'm a doctor, these lawsuits can take place anytime. Tomorrow a patient can sue me for malpractice. Tomorrow I can run over someone. So let me protect my assets today while I can. So we set up all of these wonderful magical structures that we will discuss over the next 3 hours. Some time goes by, and this lawsuit against the nonprofit and against the doctors is concluded. Judgment for the plaintiff, $5 million. This is a real case. $5 million judgment against the nonprofit and each of the directors on the board, joint and several liability. The nonprofit has $1 million of insurance coverage, somewhat reduced by attorney fees. So now each of the directors on the board is personally liable for the remaining $4 million of this liability, of this judgment. Each of the directors on the board had sufficient assets to pay off the $4 million liability. My client was the only one not pursued by the plaintiff in their collection efforts. Why is that? My client, just like the other 4 guys on the board, had sufficient assets to pay off the liability. So why was it that he was not pursued? Well, there's actually an old joke on point. You probably heard it. 2 guys are camping in the woods. A bear comes out. One of them sits down, starts putting on his running shoes. And the other guy goes, "Why are you putting on your running shoes? You cannot possibly outrun the bear." And the other guy says, "I don't need to outrun the bear. I just need to outrun you." Well, this was exactly the same set of circumstances. My client, my doctor, did not need to make his assets impossible to get to. He just needed to make his assets more difficult and more expensive to reach than the other 4 co-defendants, the other 4 directors on the board. That's it. The plaintiff will always follow the path of least resistance. What is the cheapest, the most cost-effective way of getting to the debtor's assets? that is what the plaintiff will do. Obviously, not in every case. You will have the set of circumstances where there are other defendants, and we just need to make it more difficult to protect our client's assets. But the analysis remains the same. It's all about making it more difficult and more expensive for the plaintiff to get to our client's assets. And if we can make it expensive enough, and if we can make it difficult enough for the plaintiff to get to our client's assets, what have we accomplished? Well, the statistics that we have compiled in our practice over literally thousands of cases is the following. When we set up an asset protection structure for a client, approximately two-thirds of the time, the plaintiff, the creditor, will simply walk away. They will just walk away. They will not try to do anything. Two-thirds of the time. Of the remaining one-third of the cases, the vast majority of cases, the plaintiff, the creditor, will now be more willing to negotiate. But now they are negotiating on terms that are a lot more favorable to our client. In maximum 1% of cases, maximum 1% of cases, will the plaintiff actually try to pierce the asset protection structures that we have set up. 1% of cases. Sometimes maybe successfully, sometimes unsuccessfully, and I would say most of the time unsuccessfully. So from a purely statistical standpoint, by setting up these structures, these asset protection structures that we will discuss today, the client places himself in a fantastic position. Again, two-thirds of the time, at least in our practice, the plaintiff simply walks away and doesn't try to get at our client's assets, doesn't try to threaten, sue, or do anything. The rest of the time they negotiate, and in very, very, very few cases they will actually try to penetrate these structures and get to the assets of our clients. Okay? So again, and this is probably the most important point of today's talk, the goal of what we do is not to make the assets unreachable. As you'll find out in a little bit, the goal is not to hide the assets, because that never works at the end of the day. The goal is to make it expensive enough to force the plaintiff to change their economic analysis. Okay, so if you look at slide number 1, and I believe you all have the slides in the outline, you have the ability to download the slides, and I believe they're being displayed on your screens as well. So on slide number 1, you see the 4 threshold questions. This is the 4 questions that we go through, the analysis that we go through with every single new client that comes into our office. Which is, by the way, where I'm standing right now. We do not always go through this analysis in an explicit way. Maybe it's an implicit analysis that we do, but we have to analyze each of these factors. So let me walk you through them briefly, because this is very important. The first question is, what is the identity of the debtor? Meaning, who is the person that is being sued? Who is the person against whom a judgment has been entered? Sounds like a simplistic question. Well, we know who the debtor is. That's the client who just walked into our office and gave us a check to represent them. Well, not quite that simple. We need to know if the debtor is married or single, because you can do different planning for a married person as opposed to for a single person. We need to know if there is a legal entity involved, because if there is a legal entity involved, maybe we will get the liability protection of this entity, or maybe the plaintiff will be able to pierce the corporate veil of the entity. We need to analyze all of those things. We need to look at the nature of the claim. And here we are primarily talking about the timing, meaning when did this plaintiff, when did this creditor get a claim against my client? Is it before we started doing this asset protection work, or is it after the fact? In our practice, and I presume it's true for everyone else who practices in asset protection, approximately 80 to 85% of clients come to us after something bad has happened to them. Meaning, after they got into a car accident, after they defaulted on a bank loan, after they stopped paying their rent payments, after something bad has happened to them. That is when they want to plan. And, it's human nature. We all would like to believe that nothing bad will ever happen to us, that we will never get sued, that we will never get into car accidents or whatever else happens to people. But, these things do happen to our clients. That obviously happens on a daily basis, because that is when they come to us. And this is how we see the world. So we usually are doing this planning sort of after the fact, when the plaintiff already has a claim against our clients. And